Hi, good afternoon to everyone on the call. As Veronica mentioned, we'll be talking about GDPR and some of the things that your organization should be concerned with and working on as you prepare for the, some of the requirements that may potentially apply to you in the future. Some of the things that we'll cover today, we'll give you a quick overview of what the GDPR is, how will it affect your organizations, what happens if compliance is not met, and then how do you obtain and how do you maintain that GDPR compliance? And, then we'll talk about some of the things that A-LIGN can do to help you with that process. So first, we'll just give you a quick overview of GDPR, or the General Data Protection Regulation. So it's a regulation put together by three European bodies, one being the European Parliament, two being the Council of the European Union, and three being the European Commission. And its biggest intent is to strengthen and unify data protection for all individuals within the European Union, or the EU citizens, as you'll see quoted throughout the presentation. Some of the main points, as you can see on the slides, the regulation seeking to strengthen the protection of EU citizens' data and unified protection frameworks that are already in place. One of the biggest differences, going on a slight tangent, between Europe and the US is that European countries or member states have very particular privacy regulations, unlike the United States, which doesn't really have a well-defined privacy regulation in place, with the exception of some states or specific industries. Some of the other things that you see under the GDPR, it does establish guidelines for personal data protection and the international sharing of such data. It does empower the EU citizens by expanding their control over their personal data. And lastly, one of the things to keep in mind, the expected implementation date or full implementation is May 25th of 2018. So with that date in mind, one of the things that you will probably notice is there's a lot of discussions, there's a lot of different points of view on GDPR and what it means, what are the different requirements of GDPR, and kind of what are the things that your organization should be doing to prepare, between now and May of next year. So the few slides will go over the main requirements of GDPR. We'll talk about some of the steps that you should be taking as an organization, and then overall some of the biggest differences that the GDPR introduces as compared to some of the prior privacy regulations that's been in place. So as Veronica mentioned, in order to get your CP and make sure that you guys are awake, we have a number of polling questions. So the first polling question is, who does the GDPR legislation protect? Answer A, United States citizens, B, citizens of NAFTA members, C, European citizens, or D, European Union citizens. So the poll should be open. I'll give you just a second, make sure that everyone's answering. Seeing some right answers, some wrong answers. We'll give you another maybe 5 to 10 seconds. Okay, seems like most of you got it right. 0% for United States citizens, 4% citizens of NAFTA members, 25% for European citizens, and most of you answered D, which is the correct answer, European Union citizens. So those are 4 folks who are citizens of one of the countries that are members of the EU and reside within the European Union. So next slide. The slide gives you an overview of the 6 basic principles of GDPR. Those principles come directly out of the regulation itself, and they do talk about the data subject's rights, or basically what companies have to do when they're processing data. So the 6 principles related to personal data are as follows. 1, the data should be processed lawfully, fairly, and transparently. 2, it should be collected for specific, explicit, and legitimate purposes. 3, it should be adequate, relevant, and limited to what is truly necessary. 4, it should be accurate and updated when known to be inaccurate. 5, it should be retained for no longer than needed for the necessary purposes. And lastly, properly protected against unauthorized or unlawful processing, access, loss, or modification. And as I mentioned, again, those are the 6 basic principles related to personal data and how that data should be treated. One of the things that you'll see in there is the processed lawfully. Lawfulness of the conditions of processing data means several things. One, that there's consent. So, the individual has given consent to the processing for one or more specific purposes. 2, it's necessary for the performance of a contract. 3, legal obligation. So the processing is necessary for compliance with legal obligation to which the controller is subject. And in a little bit, we'll go into the conversation of what a controller or a processor is. Another couple of points, vital interests, basically the processing. Again, we're all talking about the lawfulness of those processing conditions. So vital interests, that's the processing is necessary in order to protect the vital interests of the individual or of another natural person. Could be an example of that might be a medical emergency. And there's a couple of other ones. One is a public function, which basically states that the processing is necessary for the performance of a task, which is carried out in the public interest or in the exercise of an official authority vested in the controller. Some of those functions must arise under the member state or the EU law. And, the last point of the lawfulness of processing relates to legitimate interests. So the processing needs to be necessary for the purposes of legitimate interests pursued by the controller or by a third party, except where such interests are overridden by the interests of fundamental rights and freedoms of the data subjects, which require protection of personal data, in particular where that data is related to a child. So a lot of mentions of personal data. Let's define what personal data stands for. So according to the European Commission, personal data shall mean any information relating to an identified or identifiable natural person, which in this case would be the data subject, which you'll hear quite often. An identifiable person is one who can be identified directly or indirectly, in particular, by reference to an identification number or to one or more factors specific to his physical, psychological, mental, economic, cultural, or social identity. It's interesting how the European regulation does not say his or hers. I guess political correctness does not mean much over there. It's a side note, Petar, not A-LIGN. A couple of things, just to give you a few examples of the types of personal data or personal information which is covered by the regulation. Again, those are not all the different types. Those are just some of the types that will give you an idea of what all types of information will fall within those categories. The name of the individual, photo, email address, bank account information, posts to social networking sites, medical information, IP address of personal computers on the internet, indirect and direct personal identifiers such as a screen name, and then biometric and genetic data. One of the things to keep in mind as you look more into the regulation and in general privacy differences between the U.S. and the European Union is that the types or the definition of a PII, personal identifiable information in the U.S., tends to be pretty different than what European nations define that as. So whereas we will define things like social security numbers or someone's name combined with address and maybe medical history, things such as religious affiliation or political preferences in the EU would be covered as PII. So just a fun fact for you guys. Again, making sure that you're all paying attention, another polling question for you all. And the question is, what personal information would not be protected under the GDPR legislation? A, name, B, bank account information, C, email address, or D, information about your pet's health. So we'll give you a second to respond to this one. Okay, just give you another couple of seconds. Okay, seems like 98% of everyone on the call got it right. 2% said bank account information, 98% said information about your pet's health. So good job paying attention. So a couple of other points. We've been asked questions such as what's GDPR's relation to other privacy directives. So a couple of things to keep in mind. One, it applies to all the member states. Two, it unifies the EU's country-specific privacy directives and laws for protecting personal data. And then three, it operates above the level of other directives. So kind of what those key points mean is, we do talk about directives, and we also talk about regulations. The GDPR is a regulation. So directives set minimum standards, and then each member state needs to provide their own legislation to meet those standards, whereas a regulation is basically the law itself. The GDPR is meant to mainly make it easier for EU citizens to know, one, how their rights are protected across the EU, and then two, for organizations to comply with one set of laws rather than many, as has been the case mainly up to this date. So going into how will the GDPR affect organizations? I know we have folks on the line from different organizations. I know some from service providers, others from cloud service providers. So we'll just give you some information in general and then talk about some of the things that may or may not apply to you. And then we'll get into the definition of controllers and processors. So first of all, why is the GDPR important? It applies to EU, European Union organizations, as well as international organizations that collect or process any EU citizen's personal data. In general, compliance will give you increased overall data security. A lot of the requirements of the standard push for data security, privacy, disclosure of rights, and stuff like that. Two, overall, saying that you're GDPR compliant, similar to, if I had to compare this to a privacy regulation in the EU or in the US, I think HIPAA would be a good example. It's not a certification per se, it's a requirement, and a lot of organizations saying that they're HIPAA compliant, it does give them a competitive edge to begin with. So improved reputation for the organization, and then overall proof of commitment to security and privacy. A couple of things also to keep in mind. There are certain consequences if organizations are found in violation of the GDPR requirements. So some of those things, litigation, of course, damaging a company's reputation, that's a pretty given statement. But organizations now being, as of May of next year, can be fined up to 4% of their gross annual revenue, or 20 million euro, which is about $22 million, technically whichever one is higher. I think at a later time in the presentation, we'll actually go over some of the conditions. This 4% of the 20 million euro is the fourth step or the fourth violation. There's a few other steps, warnings, if you may, along the way that you will be given if you're found in violation. So we'll cover those in a little more detail later in the presentation. So who's subject to the regulation? Again, the regulation defines two types of organizations. One, the controllers, or basically the organizations that collect EU residents' data. The way that those are defined is the natural or legal person, public authority, agency, or any other body which alone or jointly with others determines the purposes and means of the processing of personal data. We've given a few examples below: pharmacists, general practitioners, tax authorities, financial organizations. The second type is the processors, or those are the organizations that process data on behalf of one of the controllers. So it's defined as a natural or legal person, public authority, agency, or other body which processes personal data on behalf of the controller. So it could be payroll companies, accountants, market research companies. A lot of the CSPs or cloud service providers would fall within that category. Could be call centers. In essence, any organization in the EU and those outside of the European Union operating as a controller or a processor of personal data of those European unions are subject to the GDPR. So if you fall within one of those categories, it's definitely something that your organization will want to look into. So the next few slides, we'll go over some of the main requirements of GDPR, some of the different changes that GDPR is introducing, and the very first one is the Data Protection Officer, or the DPO. It is not a position that is required of all controllers and processors. So we'll spend a little time going over the DPO and what the DPO position requires and entails. So as per the regulation, controllers and processors need to appoint a DPO to implement and enforce GDPR compliance. Some of the characteristics of a DPO are, that person has to serve as the subject matter expert of data laws and practices. Two would be they have to be independent, basically be able to act with autonomy and not be subject to penalties and be empowered by the organization. They do inform and advise the organizations and their employees about their obligations to comply with GDPR. They do lead the implementation of regular monitoring of the organization's data subjects and internally regulate the compliance with GDPR. And it could be a staff member, someone that the company hires in this specific position, or it could be a third party that the company chooses to employ. So Article 37.1 of GDPR requires a designation of a DPO in 3 specific cases. I know that's not outlined in the slides, but again, if you guys search for the actual regulation, look for Article 37.1, you will see the 3 main categories of companies or organizations that will require the appointment of a DPO. Then, after I outline those, I'll give you a little more information about, what happens if you're not using a DPO, or if you don't believe that you need a DPO, what are the things that you have to do. So the first type of organization, it's where the processing is carried out by a public authority or a body. So if you're a public authority or a body. 2 is where the core activities, which are the key operations of the organization, and again, all of that is defined within the regulation, so you can get more details if you guys need them or ask questions afterwards. But again, where the core activities or key operations of the organization of the controller or the processor consist of processing operations which require regular and systematic monitoring of data subjects on a large scale. Large scale is defined by number of data subjects, the volume of data, the range of different data items being processed, the duration of the data processing activity, and overall the geographical extent of the processing activity. Or the third category is where the core activities of the controller or the processor consist of processing on a large scale. Again, we define what the large scale or the size of the scale is, of special categories of data or personal data relating to criminal convictions and offenses. So as I mentioned, the DPO is not required for organizations. If you are one of those 3 types of organizations, you will have to appoint a data protection officer. However, there's a lot of guidance that urges companies to consider appointing such an individual regardless of whether that's required or not. Even when not required, a lot of companies will find it useful to designate one of those on a voluntary basis. And one of the key things about DPOs is, I've had multiple people ask questions about, well, what happens if if we're found in violation, is it the DPO's fault? At the end of the day, GDPR compliance is the responsibility of the processors and controllers of data. So DPOs are not personally responsible for cases of noncompliance. Again, controllers and processors are the ones that, would take the blame, for the lack of a better term. So what happens if you choose or elect not to use a DPO because you don't believe that you fall within one of those categories? As per the regulation, unless it is obvious that your organization is not required to designate a DPO, it is recommended that controllers and processors document the internal analysis carried out to determine whether or not a DPO is to be appointed, in order to be able to demonstrate that the relevant factors have been taken into account properly. So if you choose not to appoint one, you have to document your thought process, whether it's through meeting minutes or anything of that nature, to show that you have gone through that discussion, that you have identified the need or lack thereof to appoint a DPO, and that you have a well-justified and documented reason for not appointing one. If you do choose to appoint or designate a DPO on a voluntary basis, so if you're not required to, but you choose to appoint one regardless of the lack of requirement for your specific organization, the same requirements under Article 37 to 39 of the regulation will apply to his or her designation, position, and tasks as if the designation had been mandatory. So this overall, and I think this will be the last portion of the DPO requirements that we'll cover now, is this does not prevent the organization which does not wish to designate a DPO on a voluntary basis and is not legally required to designate a DPO to nevertheless employ staff or outside consultants, hence A-LIGN, with tasks relating to the protection of personal data. In the case that organizations choose to appoint, whether it's a consultant or someone within the organization, it is important to ensure that there is no confusion regarding the title, status, position, and tasks. So basically, it should be made clear in any communication within the company, as well as with data protection authorities, data subjects, and the public at large, that the title of this individual or consultant is not a DPO. So, key takeaway, if you appoint a DPO, whether you're required or you choose to do so voluntary, requirements are the same. If you employ someone else to serve in a pseudo DPO position, someone that's guiding you in privacy matters, so to speak, or maybe you have a privacy official, you have to make it clear that you don't use the DPO title. So that's on DPO. I know it's a lot to process, but there's also quite a bit of information out there that you guys can read related to that. So the several next few slides, we'll go over some of the key GDPR requirements and some of the key changes that GDPR is introducing. So this specific slide goes over the data subject rights. Again, you'll see some repetitive information in there. It's meant to get the point across, but organizations must identify the following rights in their policies. 1, right to be informed when data is collected. 2, the right to object to data collection. 3 is the right to access collected data. 4 is the right to challenge and change the data. 5 is the right to transfer data easily between any processors. And lastly, the right to be forgotten or erase data. That's a pretty big one that GDPR introduces and is, from what we've seen from previous regulations, a pretty major change. Later on, we'll talk about some of the different types of data and, what some of those mean in more details. But, things like you searching your name online, your name coming up, you actually, under the GDPR regulation, you will have access to challenge that and request that the, respective organizations remove that data if it no longer applies to you, or if you prefer that this data is not accessible to the public anymore. So a few other requirements or things that GDPR introduces. One is breach notification. The controllers or processors will have about 72 hours to notify data subjects and supervisory authorities in the case of a breach. The next one is the concept of consent. It's to justify processing personal data, and consent can be withdrawable. So personal data should not be processed without the data subject's consent. The data subject should be given a privacy notice if informing them what actions are to be taken with their data. And it's not that different than a lot of the privacy policies that companies currently employ, even within the U.S. Accountability. It's meant to demonstrate compliance with the regulation by deploying and demonstrating both policies and procedures related to that regulation. Territorial scope. Any entity that processes personal information of EU citizens. So it is not limited to organizations within the European Union, organizations within the United States, for instance, as we mentioned, who process information of EU citizens would fall within that scope of the regulation. Security obligations are meant to ensure the ongoing confidentiality, integrity, and availability, and overall the resilience of processing systems and services. And towards the end of the presentation, we'll give you a few pointers on kind of what are some of the different ways that organizations can show that or prove that they do have controls related to the CIA or confidentiality, integrity, and availability of the data and the systems that process that data. Pseudonymization, just related to encrypting personal data and keeping that information secured for as long as it's stored within the processors and controllers. The DPO, I know we already talked about the data protection officer in pretty extensive details, but that's the person that will be monitoring the compliance with the GDPR. That person will be appointed to each of the organizations. Privacy by design is meant to manage and minimize access to confidential data. And then some of the penalties, which we'll spend a little more time talking about, that the regulation introduces, which will be enforced for organizations that are found to be not compliant with the regulation. So the main points of GDPR, again, it's pushing for enhanced individual rights. It has a broad application of the regulation and applies to all the different member states as opposed to the country-specific regulations that we had in the past. It talks about or introduces stringent data protection, demonstrated responsibility and accountability, and penalties for noncompliance. As I mentioned, those are some of the key points that companies will be faced with. So we'll go over some of those main points in a little more detail over the next 4 or 5 slides. The first one being the enhanced individual rights. I know we already covered the first section that defines what rights the data subjects have. Things like the information, right to be informed when data is collected, the right to access the data, the right to be forgotten. So those are pretty key portions of the regulation. Then consent and privacy notices, they must be written in plain and understandable language, stating the lawful purpose for collection or processing and how individuals may perform or request changes or erasure. So again, most of you guys are familiar with the different consent and privacy notices, whether it's when you're installing an application or whether you're using a company's website or their services. Again, in this specific case, the regulation just pushes for a very transparent process and a very simply written privacy and consent notices. Again, the focus is on what's the purpose of the collection or processing, how can the individuals perform or request changes or erasure, how do they contact the organization. The next point relates to stringent data protection. So the use of encryption keys must be applied to data in transit and at rest. And as you can see on the slide, encryption and decryption must only occur at controllers or processors' endpoints. So intermediary data holders, so if you're a cloud service provider or a telecom provider, may not possess the means of decryption. Again, controllers and processors are the ones that will be in charge of encrypting and decrypting the information. Second point is access of data must be limited and monitored. We also talk about data breaches. As we mentioned, they have to be reported to the controller within 72 hours and reported to individuals in a timely manner. One of the things that you'll see as required in the regulation is the requirement for a defined breach response notification process. So does your company have a defined process similar to an incident response process, whereas the incident response process tends to be a little more focused on the technical side of what you do to a breach to remediate that. The breach response notification process is what are the company's requirements related to notifying their data subjects, notifying authorities, notifying any of their clients. And then lastly, data must be disposed of using approved sanitization methods. So when you are removing or erasing that data, what are the different methods that companies can use to sanitize that information? So next key point relates to the responsibility and accountability. So organizations subject to the requirements must demonstrate their commitment to and achievement of protecting personal data through several different things. One is implementing internal data protection policies. Pretty straightforward. Those would be specific to each organization. 2 would be developing processing activities that have built-in protection solutions. 3 would be by performing regular audits to gauge effectiveness of protection solutions. So, just because you implemented a security measure, does not mean that that security measure or control will continue to operate unless you have a way to validate that that's the case, whether that's periodic audits or certifications or alignment to certain standards which require that. As I mentioned, we'll cover that in a little more detail shortly. Also, the continuous monitoring of personal data for accuracy and malicious activity, and also regularly training personnel on personal data protection requirements and mechanisms. I know for organizations that appoint DPOs, that can also be one of the main functions of the DPO is to, one, as we mentioned, ensure compliance with GDPR, but also educate the organizations on what they need to do to be compliant with GDPR, part of that being the training that they provide to employees. So another polling question, just checking in with you guys. And the question is, what position must be appointed to internally enforce GDPR compliance? Again, it's something that's optional if your organization falls within one of the three categories that we outlined. A Chief Financial Officer, B, a Data Protection Officer, C, a Chief Operations Officer, Operating Officer, and D, a Chief Information Security Officer. So we'll give you a minute. Okay, seems like most of you got the answer right. The right answer was B, which is the Data Protection Officer. As I mentioned, there's a lot of guidance related to the Data Protection Officer. So if any of you guys have any questions, you're more than welcome to ask at the end of the presentation, or email us afterwards, or refer to the regulation, refer to the guidance that's out there related to the DPO and when your organization is required to appoint that person. So going into one of the main points, what happens if you're not compliant, or what happens if you're not meeting those requirements set forth by the regulation? The slide outlines the sanctions that can be imposed on controllers and processors. So one, a warning in writing in cases of first and non-intentional noncompliance. Two would be EU Commission-directed data protection audits. So first violation, being you're found that you're not in compliance, you'll be, warned in writing, basically, and given the option to remediate. Two, periodic audits related to data protection. Three, and there's a few other steps in between, but three is a fine up to 2% of annual turnover, or 10 million euro, which is about $11 million. And then four is, multiple violations, no plans to improve or remediate the findings or the non-compliance. As we mentioned earlier, that can be up to 4% of annual turnover or revenue, or 20 million euro, which is, the maximum amount. Technically, whichever one's higher of these two is the amount that will be assessed to the organization. Again, that's for the most serious infringements. Things like not having customer consent to process the data, not identifying or adopting individual rights, violating the core of privacy by design, transferring of data to third parties. As we mentioned, those things have to be defined and agreed upon by the data subjects. Organizations that are knowingly violating those, could fall within that category and be fined up to that amount. So another polling question. How much can an organization be fined for non-compliance with GDPR? A, 500 million euro, B, 4% of the annual turnover, gross annual revenue, and C, 20 million or 22 million US dollars. D is both B and C. So again, we'll give you a second to choose an answer. Okay, seems like we have some varying answers. 2% said 500 million euro, 18% selected the 4% of the annual turnover. You guys are right, halfway. 5% said 20 million euro. Again, that's the other half, but the right answer is D, which is both B and C. Depending on the type of violation, depending on the different requirements that your company knowingly violated, it could be either 4% or 20 million, technically whichever one's higher. So the next section, we'll talk about very briefly kind of how do you obtain and how do you maintain GDPR compliance. And then, we'll spend a few minutes talking about what are the different requirements and kind of what are the different, at the end of the day, what are the different steps that your organization should be, taking now, knowing that, you do have some time, but there are some pretty, specific requirements that you might have to abide by. So at this point, questions that you should ask yourself. So does your organization implement safeguards to ensure the confidentiality, integrity, and availability of data? 2, are the safeguards periodically reviewed to ensure that they're working as expected? As we mentioned earlier, just because you have a control in place, at a certain point doesn't mean that that control will continue to operate. You do have to have a process in place to monitor that. Is data processing sufficiently monitored to detect and alert malicious activity? So if you were breached, what controls do you have in place? And would you even have the controls and the capabilities in place to detect that you may have potentially been breached or have been breached? Then also, should a data breach actually occur, are the procedures in place to limit unauthorized disclosure of data? And also, related to that point, does your organization have a plan to notify the data subjects, to notify the authorities of the breach, the extent of the breach, the information that was released? And lastly, are employees properly trained to protect data according to their roles and responsibilities? So the concept of training, providing information related to compliance with GDPR and overall privacy practices, those are all things that your organization should be considering at this point. So some of the things that we as an organization, would suggest or would push for related to GDPR compliance. As most of you know, we are a pretty large consulting firm that does security, privacy, and a lot of compliance audits. GDPR being one of them, but some of the things that we'll cover in a minute, we'll touch on some of the other frameworks that we can also assess you against. First of all, assess and evaluate your overall readiness. So where do you currently stand? What are the requirements? And where do you need to be by May of next year? 2 will be to discover risk areas within your businesses and then provide risk mitigation recommendations to improve security, whether that's to implement controls, compensating, mitigating controls, new technologies, could be a wide range of different suggestions in that area. Highlight the recommendations to improve your business, and then, we can work with you to implement some of those solutions in your business. So at the end of the day, where do you currently stand? Where do you need to be in May or before May, and how do you get there? So some of the things that I know this is the end of the presentation. Before we go into the questions, some of the things that kind of a simplified version of what we covered today. I know there's a lot of concepts that we've introduced, a lot of different terminology that you have to learn pretty well. But overall, the project can be pretty confusing. So where do you start? Who would need to be involved? How do you go about identifying and meeting all of your obligations? How will you improve, or how would you even prove that you're meeting all the regulations requirements? So as you can probably already guess, a lot of those questions can distract you from the project's core requirements and make the entire process seem a lot more daunting than it should be. So for most organizations, again, I'm giving you some of the guidance that, if we were to do an assessment for you, again, we'll go over with you one more time. But, for a lot of the organizations, a simple approach may be to, not focus on the specific detailed requirements of the GDPR for now, knowing that between now and May of next year, there may be changes. But instead, start by building a framework to ensure compliance both now and the years ahead. As we said, monitoring of compliance, monitoring of those same controls and processes that you have in place is key. So the GDPR has a specific requirement that controllers should, again, quotations, taking into account the nature, scope, content, and purposes of the processing, as well as the risks of varying likelihood and severity of the rights and freedoms of natural persons, implement appropriate technical and organizational measures to ensure and to be able to demonstrate that processing is performed in accordance with the regulations. Again, those measures shall be reviewed and updated where necessary. So in essence, what this clause is saying is that organizations should put in place a compliance framework, which would then ensure that they're implementing appropriate technical and organizational measures to ensure that data processing is performed in compliance with the GDPR. So concepts such as compliance, regulatory frameworks, in essence, what they're suggesting is a structured set of guidelines and practices that will bring together the regulatory compliance requirements that apply to your organization, your business processes, policies and controls that are necessary in order to meet those requirements, as well as the technical measures, which would include specific procedures, staff training, audits, and then all the related technical and physical security controls that, in essence, will form an effective information security management system. So with the term information security management system, one of the recommendations that a lot of consulting organizations, A-LIGN included, again, don't take this as this is the only way to compliance, but this is just something that's internationally recognized, especially when doing business with Europe, is implementing ISO or the IEC 27001. So as defined in the regulation in GDPR, so there is a specific or explicit requirement for organizations to have in place the following. One, the ability to ensure the ongoing confidentiality, integrity, availability, and resilience of processing systems and services. Two, the ability to restore the availability and access to personal data in a timely manner in the event of a physical or technical incident. And three, a process for regularly testing, assessing, and evaluating the effectiveness of technical and organizational measures for ensuring the security of the processing. So in essence, this means that the organizations have to integrate data and privacy protection into a business as usual, and that a more comprehensive approach to information security, one which has to deal with the processing systems and services, the security, continuity, and continual security testing, could be in the form of a penetration test, is essential. This is where a framework such as ISO 27001 will come in. I'm sure a lot of you may have heard or know much about ISO 27001, but to those of you who have not, it is an internationally recognized management system standard for information security management. In essence, it describes and defines the requirements of an information security management system, or SMS, based on the established best practices. The best part of the framework, and one of the main reasons why we as an organization, recommend this as one of the, frameworks that companies should consider, is it is sector agnostic, does not favor any one technology or one solution, and could be used by an organization of any size. It does set out specific requirements for what must be done to secure information, but does provide room for organizations to determine how they implement the requirements to meet their organizational objectives and overall just risk tolerance. So that's one of the recommendations that we had. I know we're running out of time, so I'm happy to provide you more information or open up the line for questions. So Veronica, do we want to take a few questions now?
Sure. Okay. So here's one that came in.
Okay, so one question that came in, and I will warn everyone on the line, if I'm not particularly confident in the answer, I will get back to you guys. But the first question is, Article 3.2a seems to say that processors are not subject to the GDPR unless they're offering goods and services to EU citizens. How do you interpret that, i.e. any examples of processors that would not be subject to GDPR? That's a good question. I'm trying to think of an organization that would actually not offer goods and services to EU citizens. Again, if you are, one of the things that we mentioned earlier, if you are processing data of, EU citizens doing business with the EU, that again involves, processing of data or having access to data or storing that data or transmitting that data or, processing that on behalf of third parties, you will be subject to the regulation. So let me get back to you on this one. I'll see if I can find some examples. But, I cannot right off the bat think of an organization that would, be excluded from that. Okay, let's see, anything else? So, given that May of 2018 is the go-live date, when would you recommend pursuing certification for GDPR? So, one thing I just want to make clear that to the group, from a certification standpoint, at this point it is a regulation similar to how HIPAA is has a privacy regulation. There's not necessarily a certification, so a letter that will come will assess you and say you're certified, so to speak. So I would say more of an assessment against the regulation will be kind of what you'll go after. At the end of the day, it really depends. If you're a pretty mature organization, you've already gone through multiple audits, you're aligned to a framework, whether that's HIPAA or, ideally an ISO 27001. You have strong security and privacy controls in place. You have training in place. You have controls around continuous monitoring of how those controls and processes are performing. You have the training. Chances are you're probably not going to need that much time to prepare. However, on the other hand, if you're an organization that hasn't really gone through any of those audits, maybe security is more of an afterthought, then chances are probably now's a good time to start at least thinking about, okay, well, what should we do? What needs to be done between now and May of next year, and what are some of the key steps within that process? And that's something that we can definitely help you outline and get you thinking in the right direction. Okay, so let's see, what are the other questions? So another question, so if my organization is ISO 27001 certified, can we then claim GDPR compliance, or is it a separate assessment report specific to GDPR required? So as I mentioned, GDPR has multiple requirements. One of them is to ensure the confidentiality, integrity, and availability, as well as the resilience of processing systems and services. Then your ability to restore data in a timely manner. Then 3, the ability to demonstrate the process for regularly testing and assessing your overall operating effectiveness. So that's something that ISO will address, but as I mentioned, those are some of the requirements of GDPR. There are additional requirements of GDPR specific to the data subjects, rights and expectations of the processors and controllers. So ISO 27001 is a great start and would address a lot of the key requirements, but you should still do an assessment against all the additional requirements that GDPR introduces. So another question, what additional efforts would an ISO certified organization have to implement to be GDPR compliant? As I mentioned, the ISO framework, ISO 27001, does, give you the basic, the basic confidence, or covers the basic requirements that you do have controls over the CIA of your processing systems. You do have the ability to restore. You do have regular testing. But as I mentioned, there's a lot of other requirements specific to GDPR, such as, do you have to appoint a DPO? That's not something that, just a simple example of what may be different from ISO to GDPR requirements. Then, some of the other things that we covered, the breach notification requirements, the consent, the privacy notice, accountability, some of the security obligations, privacy by design. All those are things that you wouldn't necessarily cover in an ISO audit. Some you may cover partially, but we do, one of the things that, and you can actually find this on some of the ISO blog sites, is a mapping of ISO 27001 to the GDPR requirements. So you'll see what you've covered or what you would have covered through your certification, and then if there's any additional things, you can see those on there as well. And as I mentioned earlier, we're also happy to give you guidance and point you or walk you through some of those requirements as well. So another question: if you are a holding company that has several hundred companies operating independently, how do you implement GDPR? It will be difficult to implement at the parent company level. That's something that I will do a little more research, but my initial thought would be that you would have to implement those best practices, so to speak, or pretty much all the requirements of the regulation at each of those companies. I'm assuming, the parent company and all the subsidiaries are probably not in the exact same line of business, not the exact same size, and don't process or store data the same way. So chances are, at a 90% confidence, you'll have to assess those at each of those companies. But, I'll look into that, and, maybe we can post a Q&A section afterwards, chronicle with some of those questions and answers. So another question. If you're a data center in the USA, are you still counted as a data processor in the EU? So the one question in here would be, if you're a data center, are you doing any business with European organization? Are you storing data of those European organizations? Again, if you're just providing infrastructure as a service or platform as a service to U.S. companies, and you're storing information or you're not storing information of EU residents, I don't think that you will be subject to the regulation. But if you have any concern or any possibility that there may be information of EU citizens that you're storing on behalf of another company, then you will most likely be covered as one of the processors. So another question, will there be a certification available in the future for GDPR? That's a good question. A lot of people are asking this, and I can tell you right now that there's not a definitive answer. As happens with a lot of other privacy and security frameworks, they tend to evolve over time. A lot of the questions that you guys are asking, and consulting firms like A-LIGN are also asking of the regulators is, the set of requirements, is that everything? Will there be a framework? Will there be a defined set of controls, both related to privacy and security, that companies would have to align with or comply with? That's why I mentioned a lot can change. And, the recommendations that I made earlier to not focus on every single one of the requirements, but focus overall on your capabilities around securing your information, the data itself and the systems, ensuring the confidentiality, integrity, and availability of data are some of the key steps that you should be taking now at this point. There's a pretty good chance that there will be additional guidance released, before or between now and May of next year. But, will there be a certification at some point? Possibly. It could be more of a regulation similar to, as I mentioned, HIPAA earlier, where it's not a certification, but if you're found in violation, then those fines will be assessed to your organization. So more to come on this one, I guess, is the short answer. And let me see, a few other questions that we got earlier. One of them was, if we already have a similar role to a DPO in place, can we simply change the title? You could change the title of that person, but as I mentioned, there are certain requirements of what a DPO should be doing and what the DPO is responsible for, and also how the DPO functions within an organization. As I mentioned, the DPO is there to enforce and to educate on GDPR requirements. They have to be able to act with authority. So all those requirements that are defined for what a DPO should be doing are ones that you should ask yourselves, let's say you have a privacy official, does our privacy official meet most of those requirements? From my observation and having the pleasure of speaking with multiple privacy officials, I can say that the standard privacy official role, whether it's a GCO or someone else within an organization, would not comply with all the requirements set in place for the DPO. However, again, you may be able to repurpose, so to speak, someone within your organization, but again, one, make sure that you are truly required to appoint a DPO. Two, if you are electing to voluntarily appoint a DPO, all the same requirements would apply to that DPO. And if you are just going to appoint a person, maybe a privacy professional within your organization, to be in charge of overall privacy and security compliance, maybe GDPR, make sure that you're not using the title DPO. Well, I think that's all the time that we have for today. Thank you all for joining the webinar today. If you have any questions whatsoever, please feel free to send those additional questions related to GDPR or anything else privacy related to info@a-lign.com. Again, appreciate your time today. Hopefully you learned a few useful things. And, we're here to help. Don't hesitate to contact us. Ask any questions. We're more than happy to help you. Thank you and have a great rest of your day.